One more for you. My first ever hearing in front of a judge as an attorney was a Social Security disability appeal. My client had been crushed at work a few years ago, and his entire left side of his body was mangled. He had PDT from seeing his dad shoot himself as a kid, loads of mental health issues and physical ones as well. Just my luck, I get the biggest dickhead judge the SAW has to offer. It's sort of an unspoken rule that you don't interrupt someone's opening statement. You don't make objections. You don't interrupt. Well, I get 3 sentences into my opening and I was listing his conditions, and the judge screams over me, "You forgot one. What about the drug abuse disorder? When was the last time your client did heroin?" I froze for a half a second, glared at said client, and said, "Well, Your Honor, I didn't mention that, similar to how I didn't mention his prediabetes and seasonal allergies. It isn't relevant to his ability to work as he hasn't abused drugs in several years." Additionally, he admitted that he used drugs to cope with his mental health disorders, which he has taken much better control over since he began counseling. I was damn proud of that response. My client won the case. I called to tell him. His guff answered and informed me he was in jail for the next 36 months for stealing a car. A person involved in a motorcycle accident who sustained legitimate but not serious injuries. Ketzvay showed the incident. They were very much not at fault. They decided this was their big payday, claimed they could barely walk, had PDT, serious back trouble, would never work again. The whole 9 yards. Neglected to tell their lawyer they had been working a manual labor job, riding motorcycles. Again, we did a bungee jump, all of which we caught on video, documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued for fraud. It was a fun phone call after we sent the tape full of evidence. Special education case. Mother and school were fighting about services. We got new assessments that backed up the mother's claims. Local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route. Some extracurriculars kid was excited about, goes to enroll him in school, says they have a problem with paper twonker. The transfer info just didn't get there yet. I take a copy and head down there. I know they won't enroll him because not his legal name. She is not his legal mom. Turns out she was the fief of a mother who was pregnant and about to be incarcerated for drug trafficking. Theft says, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and husband say sure. They sign a piece of notebook paper. 12 years later. Smy, how have to think. How did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They'd just been using an assumed last name of the pseudo-adoptive couple, and, like me, no one had asked. Was only that the school had moved to an online system that checked CCS against other databases that it was cutting way by mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him, adopting, missed a week of school, while I convinced them that he fit under a homeless youth school stability statute. I was on the other side, but I saw the other lawyer seemed to have one of these moments. So the plaintiff sued, saying the insurance company had improperly denied her claim for homeowners insurance after her claim for property damage had been denied. I don't know what she told her lawyer, but as the examination under oath like a deposition proceeded, and I laid out more of the details, I think the other lawyer understood. So basically, if a pipe bursts in your house and causes water damage, that's probably going to be covered. There's generally an exclusion that says you don't get coverage if the pipe burst because you didn't take reasonable care to keep it from freezing. This person left her upper Midwest home at the end of the summer and didn't come back until like March. Didn't winterize the house, didn't shut off the water, didn't make sure the heat was on except for a tiny heater on the second floor, and didn't even have anyone checking on the house. Well, pipes froze and burst all over the house. The water utility calls her and says there's a lot of water going through your meter. You might have a leak. She calls someone to go check on the house, but they can't get in because the fucking door is frozen shut. Fuck it. They abandoned further efforts to check on the house. The water utility sent someone out, and they figured out that many hundreds of thousands of gallons had gone through the meter and they cut the water off at the main line. She doesn't come back until spring. Over time, there was freezing and thawing. Then, when it warmed up, the place molded through and through. Everything in the house was completely fucked. If I had to guess, she left out a lot of those details when she described the case to her lawyer. Co-suspect was defended by another lawyer, who argued in his closing arguments that there should have been a police lineup during the investigation, since the suspects were brought into the station when the victim was still there. Client turns to me and says that there had been a lineup and they were not identified. This lineup was about 30 minutes after the alleged robbery. Nothing in the file suggests a negative police lineup. We do trials based on written statements by police. They are hardly ever in court to testify. I mention what my client said in my closing arguments. The prosecutor's mouth drops and she becomes pale. Hearing is suspended for further investigations. A couple of weeks later, police officers are testifying in shame that they forgot to finish the report on the police lineup. The prosecutor's case is thrown out for irreparable harm to the trial. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily meth user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rock star mom to a kid with special needs. Unlike 90 of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning meth user I've met. But fuck, that hearing would have gone quite differently had she mentioned that to me beforejnied. Most of the time we can deal with bad facts. At the very least we can give you the advice you need to hear, but there isn't much I can do with surprise facts in the middle of a trial. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. Was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation, or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to shit, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter, for her charge. Life discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial, in passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as frig, unethical and common practice for that prosecutor office. I get the interview in all of 4 minutes, and she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense. I had a come to Jesus talk the next day, and she took her offer, which was the minimum of 5 years to serve. I was representing a man that was accused of sexually assaulting the young daughter of his girlfriend, who was married to another man. The key issue was whether or not my client's DNA profile should have been at the scene. Only skin cell tissue had been recovered, not semi-non-delivery fluid DNA, and it was not an exact match, but rather a match to a profile that included him. A few weeks before trial, he finally told me that the woman's other son was likely his. They had been having an affair for more than 5 years. The fact that the boy shared his DNA was a pivotal reason that the DNA profile would have been present. Edit. Grammar. A big issue was a language barrier, as my client did not speak English, and we used an interpreter for all of our communications. Deleted. Had a guy with a DUI. Asked about any criminal history. He said no. So I started the paperwork for art for him. It's a first-time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the doc, find out the guy had another DUI a year prior, also was on probation from the first one still. His excuse for not telling me was the first DUI was made up and he wasn't intoxicated, but pled guilty anyway. Unfortunately, I ended up representing him for both bases. Did not get paid nearly enough for the shit I went through, but I did manage to keep him out of jail so he could take care of his elderly mother. Made him give up his vehicles though. My client was badly hurt in a car accident and promised me he was never hurt in one. Beffrey was actually hurt in 44 prior accidents, all of which he filed claims for, which is how I found out when the mediator showed me the defense's ESO report. The fucking look on my client's face. Now client comes to me with his new wife, complaining that he's been sued by his ex-wife for failing to pay a $5,000 judgment to the ex as part of the divorce decree. Judge orders us to mediation. Ex-wife won't budge, that she wants the full $5. Client claims he doesn't have the ability to pay it. New wife, in an effort to get her loving husband free from the clutches of his evil ex, offers to give up her large dime and wedding ring to the evil ex. Ex can't keep it, sell it, whatever, but client had previously told new wife it was worth more than $5, so it should be. An Alcus wife agrees to accept new wife's ring, subject to an appraisal. Maybe you can see where this is going. To get a call 2 weeks later from opposing counsel, deal is off. Why? I asked. Turns out the ring was a cheese, worth about $95. Sean client met with me, and I showed him the appraisal. He said, yeah, I knew that was going to happen. I stared at him slack-jawed and said, you knew? Oh yeah, but what was I supposed to do? Tell my wife I got her a fake ring? How about telling her, no, my love, I gave you that ring, and it is a symbol of my love for you, and that horrible bitch will get it over my dead body. I'll find another way to pay her. I said. He looked at me and says, yeah, that would probably have worked. I had a client on a family matter. We were in court, and I was going on about how being a father was the most important thing in the world to him. And his ex pipes up and says, well, he never sees his other children. I'm sorry, other children. That being said, many clients leave out embarrassing things until they get called out on them. Please tell your lawyers all the facts. We've literally heard everything and really don't care. Just let me prepare to explain that your weekend habits of cocaine and sex dungeons doesn't affect your ability to parent. This one is the opposite of the rest, as it went in my client's favor, but I will share it because it is a somewhat funny-if-a-piece story. I represent individuals who are applying for or have professional licenses, for example, nurses, doctors, real estate agents, roofers, etc. One time, I was retained by a guy who was applying for a nursing license to begin his second career as a nurse. The only problem is that this guy was previously charged with murder, not manslaughter, alleged first-degree murder. He pled down to a lesser offense, but I know that the nursing board is not going to be thrilled with the idea of giving an accused murderer who was convicted of wrongdoing in connection with the murder a nursing license. I talk with the client about the circumstances of the murder, hoping to get some explanation that we can use to mitigate his role or put it in context. After all, he wasn't convicted of murder. But the client's explanation isn't very helpful and, in fact, makes it worse because in addition to someone being killed, it was the result of a drug deal gone bad in these types of situations. The only strategy is to take the position that your client is a changed man who made some mistakes in the past, but has turned his life around. Given the well-known issues with race, class, policing, the criminal justice system, and so on, this strategy, if true, usually works, since everyone should be given a second chance, and denying a license to someone who is truly trying to be a better person often reinforces the case closo. The day before the hearing, we prepare for hours, discussing how we are going to frame our case this way. On the morning of the hearing, the client was running late, so I had a little bit of time to kill before he arrived. On a whim, I decide to do a little research to see if there has ever been a similar case to this one. While precedent normally plays a big role in legal proceedings, these licensure cases are very fact-intensive and discretionary, so precedent is almost meaningless and not worth looking into. As luck would have it, my research leads me to an appellate decision featuring the co-defendants in my client's criminal case. In the appellate decision, the court spends a lot of time discussing the facts adduced at the criminal trial. My client pled out, so he was not one of the co-defendants during trial. Each of the 4 co-defendants has a totally different version of what went down during this drug deal gone bad. None of the defendants can agree on what their roles were, who pulled a gun first, who had a gun, who shot first, who shot who. At Covert, there are 2, and only 2, things all of these 4 co-defendants can agree on. First, my client, who was a large, physically imposing guy, was asked to join the drug deal as the muscle, but was not really told that it was a drug deal, that guns would be involved, or that there was a possibility that it could go bad. In essence, he was told that this was a routine thing, and all he needed to do was stand there and look imposing so that nobody would try anything stupid. Of course, my client probably could figure out what was going on, but these facts significantly diminished his role in either antecedent, and more importantly, all 4 co-defendants agree that as soon as somebody they couldn't agree wuppled a gun, my client, who was hired to be the muscle, immediately turned and ran away. In other words, as soon as there was a sign of trouble, my client absolutely noped his way out of that situation and ran like a scared rab. When my client arrived, I asked him why he didn't tell me these facts, since they are precisely the type of mitigating factors I was looking to uncover before. As it turns out, he was so embarrassed by the whole situation that he didn't want to tell me that part. This newly obtained information significantly helped his case, and he ultimately was given his license. And before anyone comments on how bad it is that someone like this got a professional license, I will note that by all accounts, he is a really great nurse and truly did turn his life around. His story shows precisely why people should be given second chances at life, especially when due to socioeconomic factors they were never really given a first chance.